Welcome to the Environment, Climate Change and Land Reform Committee's 28th meeting of 2019. Before we move to our first item, can I remind everyone to either switch off their mobile phone or put them on silent, as they may affect the broadcasting system. The first item on our agenda is to hear from Scottish Government officials on the Animals and Wildlife Penalties, Protections and Powers Scotland Bill, and I'm delighted to welcome Leah Fitzgerald, Wildlife Management Team Leader for Wildlife Management and Biodiversity Unit, Grant McClarty, Solicitor for Animal Health and Welfare Branch, Directorate for Legal Services, Hazel Riley, Solicitor for Forestry, Natural Resources and Climate Change for the Directorate of Legal Services, and Andrew Vos, the Veterinary Head of Animal Welfare Branch of the Scottish Government. Welcome to you all, and thank you for coming in. I think for a little bit of context, would one of you be able to set out the context for the reforms that have been proposed by this bill, and give us an overview of what the scale is of the challenge in terms of animal welfare offences, first of all?
Well, in terms of animal welfare offences, there's some information we've included in the financial memorandum about the offences or convictions that have happened over the last 10 years. And looking at those, there are 773 convictions for the animal cruelty or animal fighting offences. And of those, there were 41 custodial sentences, 147 community sentences, and the rest resulted in fines. So we should bear in mind that convictions aren't necessarily a direct measure of offending behaviour, but they do give an indication. And you could look at it and say, well, if there were 41 custodial sentences over 10 years, there may be 4 very serious animal cruelty or animal fighting offences which have resulted in custodial sentences. So that's just to give some perspective. Obviously, those serious offences have raised a lot of public concern because of the very serious nature of some of these, and have been some sickening examples of sadistic or depraved behaviour. And we've seen, unfortunately, cases involving things like dogs being tied to a tree and covered in petrol and set on fire. And there have been more recent cases involving puppy farming or animal fighting, which have been truly appalling. But these are relatively rare in terms of the overall offences, but they do create a lot of understandable public concern. In terms of the overall direction of travel, we are concerned about some new developments like the puppy trade, which has been going on for a while, but we are aware that it is a very serious problem, and there are organised crime groups being involved in importing animals.
Do you think there's been an escalation in that kind of thing because the penalties have been too low?
I wouldn't say there was necessarily a direct cause and effect, but it possibly is true, and we've heard reports that organised crime groups may consider things like illegal puppy dealing or puppy importing to be relatively low risk compared to other criminal activities like dealing in drugs or firearms because of the penalties. So that's a view that's been expressed, certainly.
And in terms of the scope of the bill itself, the scope of the bill is about penalties, not about new offences. Is that correct?
Yes, that's correct. So the purpose of the bill is really focused on increasing penalties for existing offences, introducing fixed penalty notices, and looking at the powers for the enforcement authorities in relation to animals being taken into possession. So it's about penalties and powers. So it's not about creating any new offences or any new areas of responsibility.
And there's also the aspect of the powers that can be given to those who are recovering animals, in terms of, at the moment, those animals have to be kept for the length of the time in which the prosecution or otherwise the court proceedings are taking place.
Yes, there's
a change there.
Yeah, so the current powers in the 2006 Act, which allow enforcement authorities to take animals into possession if those animals are suffering or likely to suffer, and currently to allow those animals to be moved out of their possession, a court order is required. And the bill basically proposes a new procedure which will remove the need for that court order. And so it should be more straightforward and swifter procedure.
So animals can be
animals can be more swiftly
or sold on.
rehomed or sold on.
Yeah,
yes, that's right.
okay. Finn Carson wanted to come in on that.
Just on the fines for puppy trafficking, you know, we've touched on they don't regard it in the same group as drug dealing or whatever, but well, we can all see that if a dog has a litter of puppies, it could potentially be worth 10, 15, 20,000 pounds. What have the maximum fines been up to now? I know we're looking at unlimited fines potentially, but what's the maximum fine that it's been imposed at the moment? And will these new powers allow that, or is it more likely that the fines imposed through the new bill will be substantially more?
Well, of course, the fines that are imposed will be a matter for the courts, and really the purpose of the bill is to give the courts the flexibility and additional powers that they've in some cases asked for to deal with the most serious offences. So currently the fine for the potential fine for unnecessary suffering would be £10,000, and that's going to be changed to an unlimited fine for the worst cases of animal cruelty. Yeah.
Okay, Stuart Stevenson.
That's correct. Sorry, is that? Sorry, 20,000. Sorry, I've been corrected.
Apologies. Sorry.
Sorry,
the
existing fine for Section 19 offences is £20,000.
Right. Okay.
The maximum
and then
available.
It
so,
could become unlimited.
But that will become unlimited.
Okay.
Just before I go to my bit, there's something arisen there. I presume the Proceeds of Crime Act would also enable the state to recover the profits that some of these large dealers make.
Yes, so that the Proceeds of Crime Act certainly applies and has been used.
I just wanted that in the record, that was all. Thank you. My interest is essentially on how the fixed penalty notices work, and I think it might be just useful, perhaps, it might be Grant McClarty, I'm not sure, it's up to you guys, just whether, for example, the acceptance of a fixed penalty notice creates a criminal record, or what happens to somebody. And that's a general question, and I'm asking it in general relation to fixed penalty notices, but whether there are any differences in that regard for the ones proposed in this bill.
Maybe deal with that in general terms, and Grant can give any more information if necessary. Really what the bill is intended to do is create the powers to enable fixed penalty regimes of different types to be introduced in future regulations. So at this stage, we're not going to get into detail about exactly which FPN regime would be appropriate in individual circumstances. But what the bill is asking for are sufficiently flexible powers to allow us to introduce FPN regimes of possibly different types for different circumstances in future regulations.
So these are for minor and technical offences. Technical, I think I sort of can understand. What do you think minor might mean in this context? Maybe you need to exemplify that for the committee.
Okay. Well, it'll certainly be a requirement that FPN regimes will only apply to offences which would have a maximum penalty of up to 6 months imprisonment and a fine of level 5 on the standard scale, which is currently £5,000. So they certainly wouldn't apply to offences which would have penalties higher than that. In practical terms, the sort of things we can see the need for FPN regimes would be offences that don't necessarily involve harm to individual animals, but where we're trying to improve overall compliance with legislation which will benefit animal health or welfare more widely. So one example might be the licensing legislation that we're planning to bring forwards to require licensing of animal sanctuaries and rehoming centres, as well as modernising licensing for dog breeding and pet sales. So there may be some paperwork offences relating to licences or not applying for a licence or not holding a licence. So those wouldn't necessarily involve animals being harmed, but it's important to achieve good overall compliance with those regulations in future.
Now, I understand up till now, fixed penalty notices have essentially been things that have been levied on individuals, whereas the example you've given suggests that it might be possible to levy them on corporate entities, because many of the animal sanctuaries are not really about individuals. Some will be, but many of the larger ones are essentially corporate entities, charities. Is the therefore envisaged fixed penalty notices can be levied on them?
Well, as I say, at this point, we're basically interested in getting the powers so that we can introduce appropriate FPN regimes in future. So we'd be able to consider the sort of detailed technical questions of how FPN regimes would operate and who the penalties could be levied on in future. But I think in principle, they could be, be levied on corporate bodies and legal persons as well as individual persons.
And perhaps my final part on this, just in relation to animal health, you've still an open consultation, but you've brought forward proposals. Now, I accept the point that's being made that they'll be implemented via secondary legislation. That's a slightly unusual approach, it would seem. Do you think that is you anticipating the results of the consultation, or will you simply be able to use the results of the consultation to amend the bill at stage 2?
Yes, I think this is partly due to the timing of the consultation on the animal health side that has been done. There certainly have been initial discussions with local authorities, primarily about the principle of fixed penalty notices for animal health offences. So there is clearly a need and a desire to have the ability to introduce FPN regimes for animal health purposes in future. So it's clear we have that need, and that's why there is provision for the animal health fixed penalty notices in the bill itself. And the purpose of the consultation is really to go into a bit more detail about what sort of FPN regimes would be appropriate for animal health in future. And obviously, as local authorities would primarily be involved in administering FPN regimes, a lot of the arguments will probably be similar to the arguments and considerations about FPN regimes for animal welfare. So that's why we thought it was justifiable to introduce the general provision in the bill, which could potentially be refined after the results of the consultation are known. So we're hoping to have the results of the consultation. Well, the consultation will close towards the end of December, on the 23rd of December. And so we'd be hoping that there would be an analysis of the results would be available early next year.
I guess a bill like this is effectively about the prevention of any kind of cruelty or harm to animals, and that's what we want to achieve from this. Has there already been an analysis of the reduction of the type of crimes that you've mentioned before as a result of these penalties being put in place? I mean, if you looked at other countries, for example, where they've done something like this, what kind of reduction are you anticipating?
Well, we're not primarily we're increasing the penalties to give the courts the powers to deal with the most serious offences in an appropriate way. So that's really what it's about. It's about trying to give the courts the extra powers.
But it should be a deterrent as well.
Yes, I mean, we have looked at other countries. There are quite complicated arguments about deterrence, and you have to balance the seriousness of the penalty with the probability of being detected or being apprehended. And clearly deterrence may work better for crimes that have more consideration and pre-planning. So crimes such as animal fighting, which might require a fair degree of preparation and planning, it may be that they'll be deterred more than somebody who acts violently and abusively towards an animal on the spur of the moment. But primarily we do see this really as giving courts the powers to award appropriate sentences that reflect the seriousness of the crimes that are committed.
Okay, Mark Ruskell.
Are there other approaches alongside fixed penalty notices and custodial sentences that can work to effectively re-educate people? So I'm thinking about awareness courses, or there may even be other sanctions such as banning the keeping of animals. Do you have evidence on the effectiveness of those, and are they covered in some way in this bill?
Well, it should be remembered that there are various options available to enforcement authorities before you reach the point of referring a case to the Procurator Fiscal. So I know enforcement authorities do a lot of generally giving advice, issuing warnings, possibly issuing care notices under the 2006 Act. when a case is put to the Procurator Fiscal, the Procurator also has the options of non-court options such as warning letters or fiscal fines, so those are available. When it comes to awareness courses, I can see the attraction of that sort of thing for convicted offenders, but we have to remember that the number of convictions are relatively small, and to do that sort of awareness course you would need somebody to operate and run an awareness course. And those at the moment there are community payback orders, and they require local authorities to set up training courses or awareness courses which people who've committed offences can be sent on. So if we're doing something like that...
Could you envisage a community payback order, say, for a convicted gamekeeper? What would be a suitable community payback order for somebody like that who was convicted of a wildlife crime, for example?
Well, I think we've considered that in general terms, but we do have to be aware of the practicalities of it, and so that would require courses, suitable courses to be available and set up and operated so that convicted people could be sent on suitable courses.
Yeah, okay. Could I just move on to SSPCA powers? So that, I mean, the bill doesn't really extend the powers of the SSPCA in relation to wildlife crime. So there is a mismatch there between the powers the SSPCA has now in relation to domestic animals and their ability to detect and help bring to prosecution wildlife crimes. Why is that? Why is there not an extension of SSPCA powers in this bill? Because they are a uniform service. They are there. They do an effective work with domestic animals. What's holding it back in terms of extending those powers in relation to wildlife crime?
Well, as I understand it, the issue was addressed in a letter in May 2017, I think, which explained that for wildlife crime it was considered more appropriate for police constables to use the full range of powers and facilities that the police have available, and that led to an increasing number of wildlife crime officers. So I think that was why it was decided to go down that route back in May 2017. I know the issue has been raised with this committee, I think maybe recently this year, but as far as we know, the SSPCA have made the offer. That offer was considered, and the reasons for not taking up the offer fully were explained in the letter in May 2017.
So the letter that came to the committee outlined a range of actions, one of which was the establishment of special constables on a trial basis in the Monolea, particularly around wildlife crime. Why can't we see the evidence, the outcome from that trial, to know whether it's a more effective route to tackling wildlife crime and supplementing the work of wildlife crime officers rather than
to comment on that point.
the SSPCA? Because I'm left with not knowing what the outcome of that whole process was and whether it was effective or not.
Yes, so we are in the process, along with the police and the Cairngorm authorities, of carrying out an assessment of the effectiveness of that pilot, and we would be happy to provide the committee with more details of that once that's been further advanced. It's at an early stage at the moment, but that is something that we will be actively doing, and we'll provide you with more information on.
Will that come within our scrutiny of this bill?
Don't have timescales, but we will look into that and hopefully get back to you with an indication of when that will be.
Right into us and give us an indication. Claudia, you wanted to come in.
Thank you, Convener. Good morning to you all. Having been on the previous committee in the last session of the Parliament, and where SSPCA powers were raised in relation to wildlife then, for me it is a puzzle as to what the clear reasons are why that ability to offer additional support to the prosecution of wildlife crime has been, as I understand it, not thought to be appropriate. And if I may say, I don't understand it, because we are in the position we're in with police constables or generally the Police Scotland being very up against it in terms of resources. And I appreciate there's a pilot in the Cairngorms, and we're interested in that. But I think it'd be helpful, from my perspective and for the committee's perspective, to understand what are the reasons why it's not thought to be appropriate. if not now, then perhaps in writing, it would be helpful to understand, because this process has gone on for quite a long time. Yes,
in terms
yes,
of
but
the reasons behind it.
It might inform what the developments are, if it's appropriate for you from the Bill team to let us know that.
Yeah, we can certainly provide more information in writing if that would be helpful. As Andrew said, it was looked at the time, and I think since it was looked at, Police Scotland have increased the number of wildlife crime officers, so there is now one in every division. They're undergoing extensive training so that wider Police Scotland people have training as well. So I think the situation
but with respect, I'm sorry, but I know from South Scotland, from evidence that I've heard and having gone out with people who are on the ground, that the police, with the very best will in the world, can sometimes take a considerable amount of time, and it's in remote areas where evidence can be damaged by weather and mustn't be touched, and all those things that come up. So I still don't really understand why that extra support is not possible, because they are really up against it. So I'm highlighting that issue now.
Okay. Angus MacDonald.
Okay, with regard to fixed penalty notices, we know that, just continuing the FPN theme, when would you envisage the government bringing forward regulations on FPNs, and are these likely to be affirmative regulations, and who do you anticipate will manage the use of FPNs?
Yes, regarding the individual FPNs, we don't have any immediate plans, but we can see, as I've mentioned, the licensing legislation that we're bringing forward might be an area where we would seek to introduce the first FPN regimes in relation to animal welfare. The regulations will certainly be affirmative, so all regulations made under the 2006 Act have to be affirmative, so the regulations would come before Parliament and probably this committee, or possibly the REC committee for animal health or farm animal related regulations. And there would obviously be a requirement to have due consultation before those regulations are put forward. Regarding who would administer the FPN regimes, I think this would primarily be local authorities. So we'd imagine they would be the ones who would be responsible for the licensing work we've mentioned, and a lot of the animal welfare enforcement is done by local authorities. Potentially there could be other bodies like the Animal Plant Health Agency or Food Standards Scotland, depending on exactly the situation and the purpose of the FPN regime that's developed.
Okay, do you envisage any capacity issues with regard to local authorities, because we always get that feedback from them?
Well, we're interested in introducing regulations that will actually assist local authorities, and we know that local authorities are certainly keen on the idea of FPNs in other areas, and we obviously have been discussing with local authorities what potential future FPN regimes might look like for animal health enforcement, for animal welfare enforcement. So generally local authorities are welcoming of that. Inevitably there will be possibly an additional task, but then there is the opportunity of recovering some of the costs of enforcement through the FPN regime itself. But these are all details that will be developed in due course when we bring forward the regulations.
Okay, thanks.
Okay. Ben Carson.
Thank you. Good morning. Just finally to tidy up on fixed notice penalties and other sanctions, can you tell me, is there a possibility within the bill to use income generated from fixed penalty notices to assist in promoting good animal welfare more widely? And if not, is there significant barriers to stop that being possible?
Well, as I mentioned, the basic purpose of the bill is to provide the overall power to allow us to introduce FPN regimes of different types and for slightly different purposes in future welfare or health legislation. So that's really what the bill is focused at, is providing that suitably flexible power to allow us to do that. And we could then, as those future FPN regulations are introduced, we could consider these issues of exactly how the income should be channeled and who should it go to and what purposes it could be used for. But in principle, there's nothing that wouldn't necessarily stop income being used for particular purposes, but that's not really the purpose of the bill at this point. Yeah.
Okay, and finally in that section, is there a potential for increasing the use of banning people of keeping animals, so whether that's domestic animals or commercial farming, or a requirement for offenders to undertake training or whatever to allow them to keep animals in the future?
Well, the 2006 Act already has the power for courts to give disqualification orders when an offender is convicted. And those disqualification orders can prevent people keeping animals or working with animals or basically having anything to do with animals. So the courts already have quite a range of powers when people are convicted of an offence. So we're not anticipating those will change as a result of the bill because those powers already exist.
Okay, thanks. I'd like to move on now to animals that taken into possession to protect their welfare. Now, in the last 13 years, there's only been 40 times where court orders have been used to allow local authorities to take animals away for either their welfare, to be rehomed or destroyed. Now, the government have said that it's not possible to produce reliable figures for the total number of animals. So why is that the case? And do you think that should raise some concerns, particularly given that the bill would allow animals to be taken into care or whatever without the requirement of a court order?
Okay. Well, just to correct you slightly, the enforcement authorities have the powers in the 2006 Act to take animals into possession, and the court order comes in when they then need to deal with the animals after they've been taken into possession. We did ask all the 32 local authorities in Scotland for as much information as they could provide on the times when they'd taken animals into possession and then sought court orders. But remembering that we're asking them to give information over the last 12 years and there was no formal requirement to record information in any particular format, there's a variety of different ways local authorities have dealt with this, and some of the information will be on case files that are several years old now. We did get a lot of useful information from several local authorities, but we couldn't honestly say we had a complete picture, so that's why we said we couldn't provide reliable information overall. And bearing in mind that some of these cases can involve varying numbers of animals, so they can include 1 or 2 animals, or in case of farm animals, they could include several hundred animals. So there is a wide variety in the number of animals that have been taken into possession and the different outcomes for these animals in terms of court orders or being sold on or rehomed.
Okay. Is there particular circumstances and the provisions in the bill that are specifically aimed at things potentially for councils to recover costs for caring for commercial animals over a period that they may be seized or whatever? Or is it to address more general issues right across the board?
You talking about in relation to the arrangements to take animals into possession?
Yes.
Yeah. Well, regarding cost recovery, the existing arrangements do allow local authorities to recover their costs from the proceeds of sale of the animals and from the owner of the animals. There can often be practical difficulties in doing that, particularly if they have large numbers of animals in their possession for long periods of time. So the purpose of the new process is to allow them to more quickly make proper arrangements for those animals, which will minimise the cost to them. That's really what it's about. Regarding why we're doing this, it is really primarily aimed at improving animal welfare by allowing animals that have been taken into possession to avoid suffering, to allow proper arrangements for those animals to be made reasonably swiftly, which will benefit their welfare. And we are probably primarily thinking of commercial situations where it might be commercial dog breeders or farm livestock. Those are probably the most problematic situations. Potentially also the animal hoarder scenario where somebody has acquired a large number of animals and they need to be properly dealt with. So it's really about allowing animals that have been taken into possession in those situations to be dealt with swiftly and efficiently to benefit their welfare. And it will also hopefully allow a smoother process so that local authorities can use the powers they were given in the 2006 Act, which was a major improvement at the time by allowing animals to be taken into possession to prevent future suffering. That was a significant improvement. So it allowed enforcement authorities to use those powers effectively as was originally anticipated.
So where is the decision actually taken? So, for example, if a member of the public reports what they see as potentially an animal welfare issue, where is the decision taken, and at what level is the decision taken to, for example, to seize puppies or seize dairy cows, for example, and then process them really quickly? So it could be in the case of puppies, you want to rehome these puppies within within 6 weeks, if you like. Where does the burden fall for somebody to make that decision? And once they've been through the court case, is there a compensation consideration if there's no prosecution then delivered, if you like?
Yes, well, currently the enforcement falls regarding puppies and companion animals. That enforcement is largely done by the Scottish SPCA, so they're the ones who take the animals into their possession to protect their welfare. And they can do that, as I say, under the existing 2006 Act provisions if they consider that the animals are likely to suffer in future or actually are suffering, and they can get a vet to certify that, in their opinion, the animals are likely to suffer unless they're taken into possession. They then have that power and can use it. In farm animal cases, it tends to be local authorities who take those sort of cases on. So again, they reach a point where they take the decision that the appropriate way to deal with this is to take over the possession of those animals and usually take them away from the farm they're on and care for them somewhere else. So that's how the decision is made. It will be really to the enforcement authority, which will be the local authority or the Scottish SPCA, to take that decision to take the animals away. And you asked about compensation. Now, under the current arrangements, animals, this usually applies to farm animals, can be sold on, and the proceeds of that sale do belong to the owner of the animal, but the enforcement authority can deduct their reasonable expenses from that value. Under the new arrangements, because we're seeking a swifter resolution, we've made arrangements to compensate the owner, but with the important proviso that that compensation can be deferred if there's an ongoing related criminal case, and ultimately a court will be able to order that any compensation is not paid to the owner if a court thinks that's appropriate after due process and a conviction. So that's an important safeguard that we're making.
Okay, thank you. Now moving on to questions about attacks on service animals. Got Angus MacDonald.
Thanks, Convener. Yes, looking at a Scottish Finns law, the Scottish Government has told the committee that attacks on service animals are more likely to be prosecuted as malicious mischief or vandalism than under the Animal Welfare Act, which is being amended by the bill to strengthen provisions in respect of such attacks. So could you explain to the committee why that is, and why, if in that case the amendments to the 2006 Act are considered to be needed?
Yes, well, how offences are dealt with, it's primarily a matter for the police and the Procurator Fiscal Service. But we have discussed this with the police, and my understanding is that in the past some of these attacks have been part of wider offences involving public order, breach of the peace, other assaults on police officers. So the police and Procurator Fiscal Service in those situations have decided what the appropriate offence has been, considering the overall pattern of behaviour. The change we're trying to make in the bill to introduce what's known as Finns law, as you say, is really making it easier for offences that have involved unnecessary suffering to police animals to be prosecuted under the 2006 Act. And that will require courts to disregard whether or not an action was for the purposes of defending the offender or another person or another animal. Currently, courts are required to have regard to that in deciding whether suffering was unnecessary or not. But when we make the changes, courts will be required to disregard the fact that an action was to defend a person or property in relation to attacks on service animals, which will basically be police dogs or police horses. So by doing that, it should make it easier for these sort of attacks to be successfully prosecuted under the 2006 Act. And this will recognise the fact that these service animals should be regarded as sentient animals capable of suffering in their own right, rather than as police property or something that can be vandalised. That's really the principle behind it.
Okay, thank you.
Mark?
If you saw a wider applicability to the application of Finn's law, because we're talking here specifically about service animals. But for example, can you use the example of, say, a racing greyhound? If somebody beat a racing greyhound at a track, but they used a defence saying, "Oh well, I was trying to ensure that this greyhound wasn't going to attack another animal or damage the property of another person." That could be used as a defence. I'm trying to get clear in my mind why this applies to service animals, but not other forms of working animals.
Yeah, I think for practical purposes, we have to remember that police service animals are put in positions where they are trying to apprehend individuals or maybe control the movement of crowds, and they're particularly vulnerable to incidents where somebody may attack them and then potentially argue that that the purpose of that attack was to defend the individual. So it's those particular circumstances where this possibility of talking about self-defence might arise in relation to police and dogs and police horses.
Would you not see though racing greyhounds being in a similar position, where they're in a very vulnerable position and they can be attacked by handlers?
I think it would be harder then for a handler to say that they were beating a greyhound in order to defend themselves, because the greyhound is obviously not being used in a way that's trying to control the handler or posing any danger to the handler. So it's really about the practicalities of how the arguments about whether the action was in self-defence or not would arise.
Right. Okay.
Okay, we'll now move on to the Posty review recommendations and questions from Rachel Hamilton.
Thank you, Convener. The recommendations of the Posty review were broadly recommended, accepted by the government at the time of publication. I'm interested in the impact statements, and after the conversations with the Scottish Government and the Procurator Fiscal and Police Scotland, the Scottish Government had accepted that the current system actually works, and using those conservation, ecological and animal welfare impact statements where requested do work well. It was then considered that it wasn't necessarily to legislate further. So my question is, was this reassurance from Police Scotland and the Procurator Fiscal what led the government to not accept the recommendations in the review from Posty?
So we spoke to stakeholders and they confirmed that they are using these statements where they feel it would be necessary and be helpful. They already have the powers to do this, so there was no need to put on a statutory basis and legislate just for the sake of it, because this is something that's being used and there are circumstances where it might not be required or it might not be helpful to produce an impact statement. So we don't want to be putting an unnecessary burden on people to produce a statement if the decision is made that it's not required in that case.
So they're not actually requested as a matter of course, is that what you're saying?
The decision is made in individual cases as to whether an impact statement would be required. So that's how it's working at the moment, and stakeholders feel that that's working well and they have sufficient ability and powers to use them when needed.
Okay. So moving on, in relation to the recommendation of a further recommendation from Posty, that forfeiture penalties are extended and made consistent across wildlife legislation. What forfeiture and alternative penalties were considered as part of the background to this bill, and why were the alternatives dismissed?
So, in terms of forfeiture penalties, so forfeiture penalties are available already in legislation, and there are also powers under the Proceeds of Crime Act. We are looking at possibly introducing fixed penalty notices as an alternative form of penalty, and that's something that we intend to consult with. We've already had some discussions with stakeholders, so that's one of the alternative provisions that we are looking at.
Sorry, can you just repeat that last bit?
So, yeah, we're looking at, in terms of alternative provisions, looking at fixed penalty notices, as has been looked at for animal welfare and health offences.
Okay, so just to be clear, you're not looking at alternatives as recommended. Why were the alternatives dismissed?
Well, that's one of the alternatives that we're looking at.
Right.
Fixed penalty notices.
Okay. My next question is about firearms legislation, which obviously is reserved to the UK government. But what discussions are the Scottish Government having with the UK government with regarding the relationship with withdrawing shotgun certificates and wildlife crime? And what plans are there to amend existing UK legislation that you know of?
Not aware of any plans at the moment. We have spoken to colleagues in Justice who lead on firearms legislation, and there are a number of areas relating to firearms, not just wildlife crime, where the Scottish Government would like to see amendments. So Justice colleagues are having regular discussions with the Home Office about that. The Home Office, as far as we're aware, doesn't have any plans to bring forth new legislation, but certainly we will continue to have these discussions with Justice colleagues, and if an opportunity presents itself, that's certainly something that we would be looking to consider.
Okay. Mark Ruskell touched a little bit on the preventative strategy for wildlife crime, and it was a recommendation of the Posty Review that empathy training is given. I just wondered if you had any comments about those awareness courses, a little bit like rehabilitation after speeding or other driving offences that could be brought in to create a preventative strategy for wildlife crimes.
Yeah, so there are powers already, but there aren't any specific courses of that kind that are currently being run and developed in Scotland. So in order for the court to have that, make that as a provision, there would need to be a suitable course. And as Andrew said, I mean, thankfully the cases are quite low. So it's we're looking at it's the practicalities of having suitably qualified people being able to deliver these courses and having sufficient numbers on these courses. So it's not something that we've ruled out, but there isn't a clear and obvious course available at the moment that we could look at. But if one were to be developed by stakeholders or something, certainly we would look to see if that would be appropriate.
Okay. Now I have some questions on vicarious liability from Mark Ruskell, followed by Claudia Beamish.
Thanks, Convener. I understand there's been only 2 vicarious liability restrictions that have been put in place in the last 7 years. So there are, I think, questions about whether the current extent of the use of vicarious liability is effective or not in terms of tackling wildlife crime. I'm wondering what representations you've had on this topic in relation to the bill, and what consideration you've given to extending vicarious liability within the bill.
We haven't had any specific recommendations about extended vicarious liability. Through speaking to the police and the prosecution service, it is something that they will always consider, and if they deem it appropriate to, and if there is sufficient evidence, then they will seek to bring charges. Lord Bonamy, in his review of the Protection of Wild Mammals Act, did recommend introducing vicarious liability for offences relating to hunting with dogs, and that is something that we are currently looking at, and when we bring forward legislation on fox hunting, that's something that we'll consider whether it be appropriate to implement that recommendation.
Okay, but no plans within this bill?
So this bill is about increasing the penalties for existing wildlife offences, so it's not seeking to create any new wildlife offences.
Did you have a question? Yes.
Thank you. It would just help seeking clarification in relation to vicarious liability, whether if there has been an alleged crime and but there's not been anyone prosecuted for it directly, whether it's still possible for there to be a vicarious liability prosecution, even if there isn't somebody who is the actual perpetrator who is being considered for court action. It's just helpful to clarify that because there is some concern around it, and it does relate to this bill to a degree.
So, in order for the a charge of vicarious liability to be brought, it's not necessarily necessary for somebody to have been convicted of the underlying offence.
Right.
Often, you know, that does happen, but it can still be considered if there isn't somebody in actual conviction. But again, the Crown would have to be, you know, content that there was sufficient evidence that they could bring that charge.
Right, that's very helpful. Thank you.
Claudia, would you like to continue your questions on evidence gathering?
In terms of wildlife investigations and leading through into issues around video surveillance, I'd like to look at that area now. But slightly more broadly, given the nature of wildlife crime, and it's already been highlighted that it's remote and weather can affect it, and the evidence, and often, I retract that word, it can, evidence can be removed as well. And so the likelihood of being apprehended is clearly an important factor in this bill, and is as a deterrent factor of sentencing. So how does the bill impact on the ability of authorities to investigate and gather evidence of serious wildlife crime?
So one of the things that the bill is doing is increasing the time limits for prosecutions to be brought, and through speaking to the police and the Crown and also stakeholders, they have all said that there have been cases that they have not been able to pursue because of the time limit, for very much the reasons that you have alluded to, and also there's quite a lot of complex forensic testing that can sometimes be needed to be undertaken. So stakeholders feel that certainly this would be helpful in that it will allow them more time to investigate. And as I said, they were all able to give examples of cases where they had fallen under the time bar, where if the time bar had been longer, they might very well have been able to bring a charge in that case.
Right, thank you, that's helpful. And specifically in relation to video surveillance, you'll of course know as a panel that the committee has heard previously about it being potentially important in gathering evidence, enabling the prosecution of wildlife crime. And we're clear that there has been some debate about the admissibility in court of video surveillance. And does this bill shift the debate in this area in relation to it being more likely to be admissible, possibly as a result of wildlife crime being treated as a serious crime now?
So, I mean, because of the increase in the penalties, it will provide opportunities for police sanctioned surveillance, for them to consider that, providing that, you know, it's considered that this would be appropriate, and all of the requirements for carrying out that surveillance are undertaken. So that will help with that. In terms of evidence that's maybe been gathered from third parties, so this bill is not seeking to make any changes to the processes or procedures under which wildlife crime is investigated or prosecuted. So at the moment, the admissibility of evidence is wider than wildlife crime, so the rules governing it are not specific to wildlife crime or even specific to the use of CCTV or video evidence. The Crown is able to consider that, and they will do so, but they obviously have to look at it on a case-by-case basis, and they will make a decision on whether a bit of evidence can be admissible, and there'll be various reasons for that, and some of them will be legal reasons.
Right, that's helpful, and particularly in relation to third parties. There's been issues around, I think it's Article 1, Protocol 1 of the of European directive about private property, and I wonder the degree to which has that been looked into in relation to future possibility in view of the where we started with the remoteness issue and you know the importance of recognising that wildlife crime is now being said to be a serious crime.
It's not been looked at in terms of this bill, because I said we're not looking at those kind of wider areas. It's looking about the penalties. But as I said, whether it could be used or not would be a decision, and there have been cases in the past where, for various crimes, where video evidence has been deemed admissible, yes. And that will continue to be the case.
Thank you.
So just to clarify, the legality around video evidence is across any crime. It's not just specific to wildlife crime. There's actually, a threshold that has to be met in order for the police to mount any kind of video surveillance of a proposed a situation.
Yeah, so there are rules governing when police surveillance can be used, and then there are obviously operational decisions that Police Scotland have to make. And in terms of the admissibility of any kind of evidence, then there are rules governing that as well. And I think Sarah Shaw wrote to the committee in May 2017, and she kind of covered all of the rules around what the Crown take into consideration when determining whether evidence can be admissible or not.
Right, okay.
Can I just
yes.
Just on that, so this bill with the ability to increase sentencing and have unlimited fines, that should in effect increase the possibility of video evidence being used in a case. Is that correct?
No, the police have certain criteria where they can authorise surveillance. So through increasing evidence, increasing the maximum penalties for those crimes, some of these crimes might fall into that category, but it'd still be for the police to decide on an individual basis against all of the criteria whether it would be appropriate to authorise surveillance in that. In terms of video evidence from third parties, it won't have any impact in that. It will still be for the Crown to determine it under the current rules and regulations.
But the police potentially have more scope to potentially use it because of the limits used to be, it had to be a serious crime and it had to be for a case that might be prosecuted with a sentence of 3 years or above and so on. So yes. The scope for the police to consider accepting video evidence will have increased?
Yes.
Okay. Thank you. Right, Claudia, have you finished your line of questioning? Thank you very much. Just want to move on, just very briefly and finally. The Werity review was expected in summer, but it obviously hasn't. Have you got any idea of when it's going to be delivered?
Yeah, so the Werity review was originally delayed for reasons out with the control of the review group. So it's an independent review. We don't have a definite date, but we have been advised that the group are hoping to be able to present it to government very shortly.
Very shortly. Okay, right. Thank you very much. I want to thank you all for your time this morning. I'm going to suspend this meeting. Right, the second item on our agenda is to hear from the Cabinet Secretary and her officials on EU exit and the environment, and I'm delighted to welcome Rosanna Cunningham, the Cabinet Secretary for the Environment, Climate Change and Land Reform, and her officials. We have Katrina Carmichael, the Deputy Director for Environment and Land Use Strategy, Claire Hamilton, the Head of Climate Change Division, Don McGilvray, the Deputy Director of the Environmental Quality and Circular Economy Division, and Lisa McGuinness, the Deputy Director of Head of Compliance from Marine Scotland. Thank you all for coming here. Cabinet Secretary, I believe you have a brief opening statement.
Thank you, Convener, and today makes for interesting timing for this discussion. Notwithstanding where we are currently in this debate, I do continue to be deeply concerned about the negative impacts of EU exit, whenever it happens and whatever the terms. I am particularly troubled by the ongoing threat of a possible no-deal exit, and I understand as of today, of course, that the potential no-deal date shifts from Thursday this week to January is it 31st? Not quite sure, till the end of January. There has been extensive preparation to protect the environment, climate change and land reform from interest from its damaging effects. The government continues to prepare for this possibility unless and until it is fully ruled out, and we will have to continue to do so, notwithstanding changing dates. The committee will know that on 8th October, the government published the overview of no-deal preparations. I wrote to the committee last week setting out more detail on the specific actions taken across the portfolio to prepare for no deal, including to ensure a functioning statute book. But the reality is that it simply would not be possible to mitigate all the impacts of leaving the EU without a deal. There are three aspects of Brexit impacts across the portfolio that should attract the committee's attention, and this is more general Brexit impacts. Firstly, the revised withdrawal agreement and political declaration agreed by the Prime Minister, which is still live, which together raise significant concerns because the revised texts contain no legally binding commitments on environmental protection or climate change. The language in the revised political declaration on upholding common high standards is both unclear and has no legal force. And given the Prime Minister's stated intention to potentially diverge in the future from EU laws and regulations that deliver environmental product and labour standards, that continues to be a major concern. The UK government's apparent intention to move away from alignment with EU standards could also seriously undermine the development of long-term common frameworks, and the Scottish Government is not going to agree to any measures that disadvantage Scotland, place environmental standards at risk, and which don't reflect the clear desire of the people of Scotland and this Parliament. Secondly, I'm concerned about the pace of final development of the UK Environment Bill and the lack of time we were given for proper detailed consideration of its provisions. Before publication, the Scottish Government was not consulted or even made aware of the climate governance role given to the Office for Environmental Protection, replacing that of the European Commission. I've now told my UK counterparts that we must work together in a true spirit of collaboration to develop meaningful joint decision-making processes that might be required as long as they respect the devolution settlement and help us achieve our respective net zero targets. And thirdly, effective and appropriate governance to monitor and enforce environmental standards in Scotland is vital. Our consultation has confirmed key gaps will exist once we lose the European Commission's scrutiny of government performance and are currently finalising our proposals for long-term governance arrangements on the basis of that analysis. However, in the event of a no-deal exit, that gap would be immediate. I intend to appoint an interim advisory panel which will operate if a no-deal exit is confirmed. It will provide advice on the maintenance of environmental standards and the implementation of environmental law in Scotland. And because of the considerable skills he has, I have invited the former Scottish Public Services Ombudsman, Jim Martin, to chair the panel and put in place an interim approach which will follow as closely as possible that of the Commission. I hope the committee recognises the huge amount of work already carried out by this government and that is carried out and ongoing, I should say, to ensure our environmental laws and regulatory systems are robust in the event of EU exit. And I'm happy to discuss further with the committee any of these issues.
On that note, Cabinet Secretary, I mean, you say that the Scottish Government has done a lot of work in terms of preparation for a no deal. Yeah, and obviously that's taking place right across government. It's also taking place right across Parliament as well. Have you got an indication of how much from your portfolio that has actually cost, and where's that money coming from?
Well, the costs are considerable. Much of it has to be met from our own budget. We've made bids for funding, obviously, and we will continue to do so. There are significant costs in different areas. Marine Scotland, it has to be said, is where the disproportionate impact of no deal exit hits in terms of its compliance functions, and funding is awarded accordingly. The Treasury has at least now acknowledged that that is a significant issue, and they have provided long overdue funding to help mitigate some of the impacts, although at an incredibly late stage in the day. As such, it's agreed to release £5 million for compliance assets. That won't prevent all of the entirely avoidable damage, but at least it is a subvention which is significant. It is our clear expectation that the Treasury will continue to honour this promise in terms of the other very significant costs incurred by the Scottish Government in relation to Brexit, and that's the overall issue about funding for Brexit costs. I should say that Marine Scotland is now committing the funding that has been given at this late stage as a matter of considerable urgency, committing it to further enhance existing marine compliance assets. But obviously, because of the very late confirmation of the funding, we would not have been able to have the additional assets in place before the end of this week. But of course, that is now not on the table any longer in terms of no deal. But nevertheless, we cannot stop preparing for an outcome which may yet happen. So Marine Scotland has been the lion's share. There has been spend by the Directorate for Environment and Forestry and the various public bodies and main research providers. I mean, I do have sort of detailed year-by-year break. I don't know how much detail you really want me to go into with this.
No, I mean, just an overview was absolutely fine.
Yeah.
I mean,
we have been spending on Brexit. So, for example, 2017-18, 2018-19, there was £4.4 million spent by N4 and sponsored public bodies. That was primarily in staff costs. So that's the kind of thing as we go. But I can give you that more detailed breakdown by letter if you would like that.
Yeah, it would be good to actually have that detail, and you can forward that on to us. I just want to pick up another thing in your opening statement about the Environment Bill. We were looking at the policy statement that accompanied the UK, and it said that, and this contradicts what you've just said here, extensive and continued collaboration with Scottish and Welsh governments and the Northern Ireland Civil Service has also enabled us to bring forward measures that we expect to see adopted outside of England. You're saying that hasn't taken place?
I read that same statement. It is absolutely, categorically untrue.
There's been no collaboration.
None.
There's been no discussion.
Not even any notification, much less collaboration.
Right, okay.
The addition of climate change to the functions of this office. Now, let me be clear. We have known about the Office of Environmental Protection. In fact, we've known about that since they began consulting on it, and both Scotland and Wales refused to be part of it. The notion that it was going to extend to some form of oversight of climate change activity came out of the blue when that bill was published. I have to say I could be mischievous and point out that given the ambition of Scotland being considerably in advance of the ambition for the UK as a whole, if anybody was to have oversight on any climate change activity, perhaps it's Scotland that should be having oversight on what was happening from Westminster. I just find it astonishing.
And this particularly concerning because quite a lot of the targets that are in place in the climate change bill that we've just passed, a lot of that's dependent on what happens
Absolutely.
at UK level as well. Is that correct?
Yes.
Yeah. Stuart Stevenson.
I wonder if, and it may be the panel's not in a position to comment on this, another part of the EU withdrawal bill, which I think causes me great concern, which seems to be an overarching power, is the independent monitoring authority that's created in Schedule 2 of that bill, which of course Scottish ministers, as the bill is drafted, have no right to determine the membership of. I just wonder if that has any relevance to the interests of this committee. It will clearly have relevance to the interests of Parliament as a whole. Its focus does seem to be on human rights, but it does seem to cross over into environmental matters and might actually be sitting over the Office of Environmental Protection in relation to leaving the EU. And I just wonder if the Minister has anything to say on that subject.
These are some of the issues on which we've continued to try and get clarity on this. It is, these are amongst the reasons why we are unable to agree an LCM at this stage, and we've advised the presiding officer that we cannot do that at this point until we get some better clarity on this. I suspect that there was a very rushed attempt in the few days before publishing this bill by colleagues south of the border who wanted to get something out of the door. What I am not clear on is whether they themselves are clear about some of what's actually in the bill and what's intended, and that's a lot of the work that we need to do in this period of time. If we are able to have the opportunity to do that, of course, because by the end of today we could be in a completely different position yet again.
Well, that maybe leads me to my second question, which is I just see on the wire that now all the parties at Westminster are supporting the proposal for an election in early December. I've just seen that literally now. In the light of that, and that therefore implies the falling of environmental bill, what do we in Scotland lose with the environment bill that's being progressed at Westminster being progressed, notwithstanding our concerns about some aspects of it? I imagine there'll be some positive things in it that might have been of benefit to us that we might also lose. In
fairness, there had been a considerable amount of work being done, and we were in agreement with some of the things that were respective in terms of producer responsibility, and I think that's perhaps a conversation that belongs with a different committee appearance, but we had negotiated with the UK government over a long period of time about some of that, and that's what we would have been happy with an LCM on that basis. It's the levering in of these additional things that have created the problem, not those pre-existing agreed areas where we were hoping to use the passing of the UK Environment Bill in order to allow us to get legislation for some things that would have been difficult for us to do given the pressure of our parliamentary legislative timetable now. So there's a bit of a loss there. Yes, you're right to raise that, but in all conscience, I don't think I can, given the current circumstances of the bill, simply sign off on that. But of course, if the bill falls because an election is called, then it's all back to square one anyway.
Mark Ruskell.
I mean, obviously the picture's changing minute by minute. I'm getting confused.
I don't know any more than you do.
Yeah, keep an eye on Twitter, I think. Can I ask you, though, about the proposal that's in this bill for the Office of Environmental Protection, if there's any more clarity as to how that will link in with devolved functions? I mean, we've previously had, for example, the example of offshore wind farms and whether the OEP could provide some role in terms of determining, you know, consent processes around that. I'm searching for kind of real examples of where OEP will be straddling a mixture of devolved and reserved matters, or coming, you know, in on devolved matters.
It is one of the areas that we have not been able to get clarity on. From our perspective, OEP will have no role in respect of devolved issues. What we've never quite kind of got clarity on is where they thought there were kind of reserved issues that they might intervene, and that is one of the areas that we've still been unable to establish, which is why the addition of climate change to that came as a complete surprise, because we had been having these conversations about the OEP. Now, the OEP, as I understand it, is effectively a desk that simply receives things and then just passes them on to the relevant departments. It is their interim proposal, and perhaps Katrina has got slightly more information, but as I understand it, it's more of a kind of conduit for complaints and issues coming in.
That would certainly be my understanding of the UK government's proposal for its arrangement.
Yeah. And so I think there's got to be a sense in which you understand that there's an interim arrangement that they're proposing, but then this legislation is talking longer term. Quite what that would look like isn't clear, and quite what it would be intended to cover isn't clear. What is clear that both Scotland and Wales said right from the outset that we were not happy to have it extend to the devolved policy areas. So, as you heard from my opening statement, we have gone ahead with or developed a proposal for an interim position while we develop long-term scenario. And it is such a fluid scenario that, you know, I have been having conversations about setting up a kind of fix for no deal, and having to have conversations with people about something which might not be necessary if no deal is not there, but has to be there if no deal is there, and you may not know that until literally the last possible minute. So it's a slightly Alice in Wonderland scenario. And can I just put on record, I'm extremely grateful for Jim Martin agreeing to take this task on in this hugely uncertain space that we're all in at the moment. And the intention that I would have is that our interim measure would look much more like a proper setup. It's not a desk. It will do and mirror what the Commission is currently doing. Can't make it bigger than that, but at least do mirror what the Commission is doing. And
sorry to interrupt, Mark, but so you concerned, so you're putting all these sort of governance procedures and processes and potential bodies in place, and you concerned that there might be some kind of compunction that from the UK government that almost like interferes or supersedes that.
I couldn't say that, because at the moment there is really so little available for us to understand. You know, when they consulted on this particular aspect of the bill, they consulted on the basis that we were out of it, and that Scotland and Wales, and by we I say Scotland and Wales now, were out of it for devolved policy. They've always kept this odd overarching statement about it, you know, there would be some reserved policy matters, but we've never been able to establish with them what they saw those as being, and that's always been a bit of an issue, and we continue to try and press them on that. And I suppose one could argue that at least the bill progressing through a parliament might have given some ability to find out what that was all about. So at the moment, I would have to say I can't see that they are intending to do that, except with that addition of the climate change oversight. We were all taken aback, and I don't understand what that then looks like. So
right.
I'm trying to be as expansive as I can be.
No, I appreciate that.
Given the situation that we're currently in.
Claudia Beamish had some questions on that.
Cabinet Secretary, it's, in my view anyway, very, very helpful that you've highlighted the issue of the reassuring issue of the advisory panel and recognising the Commission's position. I'm wondering if you're able to say anything about the monitoring and enforcement arrangements in view of the consultation in Scotland and the positive, as I understand it, there were positive arguments put forward for environmental arrangements for monitoring and enforcement here in Scotland, and how would that, if that goes ahead, how would that be independent of government?
Well, again, can we separate a no deal from a deal?
Of course. That's why,
because these are two quite different
that's why
scenarios.
Long term.
For a no deal, as well as the panel, we would expect the existing organisations in Scotland that are doing the monitoring and enforcement to continue to do that. Obviously, there is a longer-term conversation to be had about longer-term governance in that regard, and that will take. We will be bringing forward ideas in respect of that as soon as is reasonable. Although the committee undoubtedly is aware that there is now little chance of legislating before 2021. Yeah. So, you know, the interim scenario that may come into play is one that may subsist for a couple of years. And the other thing about the interim scenario is we couch it in terms of no deal and deal, but it kind of depends on the deal whether or not you continue to have this interim scenario for longer or not. Yes. So we really are in a very uncertain period.
Thank you. And Convener, do you want me to ask something about environmental principles now?
Can I come to Rachel first and then I'll come back to you. Right. Rachel.
To the previous point, Cabinet Secretary, am I correct in saying that you are considering ways of in which the devolved administrations can work together to produce environmental principles?
I'm not clear what you mean. I mean, the environmental principles that we adhere to are ones that we all agree on, and I don't think there's a difference in terms of the prima facie agreement about environmental principles anywhere in the UK.
Okay, it was just something in the papers that had said that there was an agreement to consider ways in which the 4 UK administrations can work to provide for coherent sets of principles.
I think, yes, I think perhaps that may be a shorthand that the media has used, because the 4 environmental principles that everybody kind of knows about really are ones that are agreed with around the table. There is some discussion about additional principles, which I know that there will be members on this in this committee who will probably want to think and have a conversation about that. But the 4 that apply are those which we would anticipate putting into the continuity bill when the continuity bill is brought forward. There isn't a disagreement about those principles. What there might be a disagreement about is what the, if you like, let's assume that Northern Ireland has a minister, that you have 4 ministers around a table discussing this. Where the issue comes is the presumption on one of those ministers that they somehow have the directing role, when in actual fact they don't when it comes to anything that's devolved. So it's more an issue of that than the principles themselves.
Okay, thanks.
Claudia.
As you'll recall, Cabinet Secretary Mark Ruskell and I had some amendments to our continuity bill, which seems a very long time ago, in relation to the 4 guiding principles. We were very reassured, as I'm sure were many people in Scotland, about that going forward. But I understand that there's another possible principle in relation to integration, and also that there may be issues around human rights, principles that could be added. So there will be, you've already highlighted, there will be more things to consider, but I know the
Okay.
4 principles are there, and
Right.
and that's very reassuring. But I'm just saying there may be more.
So I should say I'm not in charge of the continuity bill, so that's slightly off centre for me. Secondly, we have agreed the 4 principles, and there wouldn't be a debate about that unless we felt the continuity bill had to be brought forward in time and introduced earlier, when there may be an issue in that regard, you know, because parliamentary drafting and all the rest of it. So I'm a little wary about getting drawn into too much detail about what might or might not be a debate at the time of the continuity bill, which at the moment is due to be introduced in spring, and at the moment is intended to legislate for the 4 environmental principles. But as we know, it's not just a week that's a long time in politics now, it's a day that's a long time in politics.
Cabinet Secretary, you've said on quite a few occasions that the Scottish Government intends to keep pace with EU standards. Yet there's been some changed language from the UK Government around that kind of area.
So. Yeah.
I mean, what is your response to that, and how would that impact?
Well, it doesn't change my intention. It doesn't change. It, I suppose, makes it even more important that we retain full control over what is already devolved, because we will only be able to do that if we are in the driving seat in terms of devolved policy. There are tricky issues around keeping pace, because keeping pace means that you also have to be plugged into the discussions and the debates and the conversations and the development of a changing thinking around things. So that will be a challenge for us, and we're looking at ways in which we can continue to do that, even if we were to be on the other side of Brexit, that there are mechanisms by which we can continue to stay plugged in. For example, there's a pan-European gathering of environmental protection agencies, and you know, we're hoping very much to be able, that SEPA continues to be able to be locked into that. And that's the kind of thing that we will need to really have a very close eye to continuing to do in order to give us the information that will allow us to continue to keep pace with developments. But it is our absolute intention to do so. But it is also why I am so resistant of anything that would give away power in this area, because the changing language that you have referred to, particularly in recent weeks as it has come back in terms of the political declaration and the withdrawal agreement, are a worry for us in that regard, because it does appear as if, perhaps not today, perhaps not tomorrow, perhaps not next week, but at some point there would be an attempt to start diverging from the standards that we have become accustomed to in the EU. So I need as much as possible, and this government needs as much as possible, to protect our environmental policy from that.
Claudia, do you have another question? No, Finlay Carson.
Given the government's position that regardless of how the UK leaves the European Union, you're going to keep pace and maintain environmental standards or exceed them, and the assurance that your civil servants are prioritising a no-deal exit from Europe, how advanced are your interim plans to put something in place for governance? Well,
I've indicated I've had conversations already with Jim Martin, who has agreed to chair this.
So when did that, what were the timescales for that? Because this has obviously been a scenario that you've been looking at right from day one. So when the vote was taken to leave Europe, your position has always been, or the government's position has always been, to keep pace and to prioritise a no-deal exit.
Well,
why are we so far down the road before we've actually got some ideas what the interim arrangements would be?
With the greatest respect, I don't think we were discussing no-deal exit right from the get-go in 2016, because at that point, obviously, everything was about a deal. No deal has become a live issue this year, and it's this year that we began to consider that we needed to do something that would allow us to provide this interim scenario. We had to make a decision about what that would look like, so there's been a bit of to and fro about that. We then had to make a decision about who would be best in those circumstances to anchor that, which is where the discussions with Jim Martin have taken place. I think I indicated in an earlier answer that because we're intending it to mirror what is currently, if you like, before the EU Commission from this country, we are talking currently live 6 cases. So this is not a court sitting getting things on a daily basis. It isn't like that. And we are simply going to have to proceed with this now in the possibility that we are still in a no deal argument. It's a very difficult set of circumstances because I'm having a conversation with somebody who is, very experienced, who knows this might not happen, but has nevertheless agreed to take it on and to begin to get up to speed with the current cases, because we have yet to make a decision about what happens. Because if you go off a cliff on a no-deal exit, every single one of those cases is finished like that. So we would need to make a decision about whether or not we were then going to uplift some of them into the new scenario, or depending on what stage they're at, were they going to fall away. All of that has to be thought about beforehand. So yes, it is an ongoing odd discussion to be having about a panel which might or might not actually be needed.
But I suppose I'm suggesting there's no uncertainty about a no deal. A no deal is a no deal. So you are working to some sort of certainty that if it is a no deal, you know what the parameters you are got to work around. So that's why I'm surprised that, given the likelihood of the Scottish Government not supporting any deal that comes forward, and your expectations or your expectation to prioritise no deal, that we don't have more certainty about what things will look like after a no deal situation, because that's not.
You mean why we would?
It's less uncertain. We know what a no deal could look like.
So you're asking me why I wasn't sitting here a year ago telling you this? Is that what you're asking?
Well, no. I'm suggesting that the lowest common denominator, the worst scenario, is a no deal. I'm surprised that we're not sitting here today where we could potentially be leaving the European Union on the 31st of October with a no deal, with a better idea of what actually might be in place, an interim.
Well, okay, so there's a lot to do, okay? There's a huge amount to do right across the board on all of this. So officials have had to focus on certain things at the expense of some other things. One of the reasons for the interim, I mean, I suppose in theory I could have had the interim panel ready to go 6 months ago, but there are 6 cases, that's what we're talking about. So in terms of the process, that wasn't the same necessity as some of the things that we've had to be doing. So all of this is really about managing what we do and what we don't do, and how we do it. So some things have had to be kind of not stopped, but slowed down in order for other things to take place. And we're not in a no-deal exit on Thursday. Notwithstanding that, this panel, with a new date at the end of January, which might or might not be, you have to understand that money gets spent on that as well. Because, if we are in a position where they may want to take or need to be taking up cases, they need to be thinking about what their approach is going to be. So people are already engaged in their time to do that. So this is all a balancing judgment about what is absolutely needed and when it's needed.
Mark Ruskell.
It's not an easy, and some of them are not easy choices to make.
Mark Ruskell.
Can I ask you about the chemicals regulations, the replacement REACH UK regulations? We've had numerous tranches of those regulations and amendments to those regulations coming to this committee. There seems to have been some limited concessions made by the UK government in terms of involving a bit more expert advice and stakeholders in the decision-making process. Are you content with where we've got to? Can you see improvements? Where's Scotland's voice represented in this regulatory structure, because we still have Health and Safety Executive effectively running this regulatory framework for the whole of the UK, and I'm a little unclear as to how we actually input into that. Where's the voice of this Parliament and the government in the regulations?
I think, broadly speaking, we're probably in this respect in about the best place we could have thought to be. I'm not going to say that I think it's necessarily perfect. There are ongoing conversations about a common framework on this, which haven't been finalised, but are moving on. So it is one of the areas where there is a engaged conversation taking place. From my perspective, this is about maintaining the highest possible standards of protection for public health and the environment, and crucially for business to make sure that they have consistency and continuity as well, because chemicals are one of those things that most people don't really think about, but underpin an enormous amount of our industry, and are incredibly important for the functioning of economic sector. I'm intending to make a case for the UK retaining membership of the European Chemicals Agency, and that is a strong view, and participation in all the relevant regulatory regimes. And if I go back to the UK Government Environment Bill, it does remove powers previously available to Scottish ministers. So that would be an area that we would be wanting to work on. So it is one of those areas where, if I think in terms of the ones that most directly affect this portfolio, that are most directly impacted by Brexit, chemicals, waste, water and the EU ETS, chemicals is possibly in about the best place in terms of the agreements that have been reached, but not ideal. And I agree that there is still a slight degree of nervousness about the IT system that's been set up, and people won't feel absolutely convinced until the button is pressed and it works. And that's more to do with IT systems than it is to do with this particular issue. Don, you look like you're itching to come in this.
No, I was nodding along with what you said there. I was like, I think you've covered the points I would make.
But, I mean, you mentioned earlier on about principles beyond the four principles. When we last debated the continuity bill, animal sentience was one of the principles. When we last debated the continuity bill, animal sentience was one of the principles that there was a commitment from the Scottish Government to take forward. It's not in the bill that's currently before this committee. So where does that fit in? Will that come back in under the continuity bill, or can it be updated in other ways?
Well, it's not one of the four principles that we're talking about in terms of the continuity bill. I'm not quite sure where the position is. I don't know if anybody here can we. I'm not conscious of where the animal sentience issue is, and I will undertake to get back to the committee on it.
Okay. Cabinet Secretary, one of the things that we ask you often around this EU exit is about where your discussions are with the UK government on replacement funding for UK funding, EU funding streams, and this shared prosperity fund. Are you able to give us an update on at all? Have there been discussions at all? Has that not moved on in terms of clarity or detail?
I still have no idea what the shared prosperity fund is intended for and how it's going to be operated. So I continue to have that same concern, as does my colleague Fergus Ewing. I don't think there's any doubt about that. Obviously, loss of EU funding poses a huge risk to environmental objectives. There's a direct financial impact, but there's a longer-term reputational impact, because there's already signs that our research is going to be adversely impacted. People are being effectively told that a UK element in a research proposal will not work, because people you know, most of these research proposals span a number of other countries, so there's a big issue there. So we are considerably concerned about that, and considerably concerned about the continued lack of information and clarity, and that won't just be from my portfolio. I do have a breakdown of current EU funding, but I don't know whether or not the committee would want to see something more detailed separately.
Happy to take that. I think we've got a fair idea of.
It's probably not anything that you're all not already aware of. But the short answer to are we any clearer, I'm afraid, is no.
Okay, Claudia.
The committee had highlighted to them, and I happened to have visited the Shant Islands, which got the EU Life money, and it was highlighted at that point that there are some really significant, big, long-term projects that have been supported by the EU, and I wonder, and I would fully expect that you have Cabinet Secretary, but I wonder if it's possible to re-highlight to the UK government that these types of long-term funding in our biodiversity crisis are really of concern, you know, to Scotland.
We raise the issue at every single one of the interministerial meetings that we have between DEFRA and the devolved administrations. And all the devolved administrations are in the same position, and we generally, at some point on the agenda at every single one of these meetings, which are taking place almost monthly, we raise it at every single one. I'm bound to say, and I may be speaking out of turn here, but I'm bound to say I'm not entirely certain that most of the UK ministers know either. I'm not sure that their refusal to tell us is because they're keeping it a secret. I'm not entirely clear that they themselves have much more detail than we have.
Okay. Finlay Carson.
Thank you. It's obviously really important if there is going to be a shared prosperity fund that it's designed in such a way that Scotland can maximise that fund. On that basis, when is the consultation that the Scottish Government is going to carry out, I think headed by Professor David Bell, when is that likely to report back? I know it's sometime in the new year, but ultimately it's quite important that's brought forward quickly so that it could potentially fit within that prosperity fund.
Not being instructed through my portfolio, Katrina, are you aware of?
You can confirm.
We'll confirm that, but it's not being instructed through my portfolio, so I'm not absolutely certain of what the reporting date will be.
Okay.
Okay. Do any of my colleagues have a final question? I think we've just about run out of time in this session. I want to thank the officials that have accompanied the Cabinet Secretary. We'll suspend briefly for them to change over to new officials to move on to the next part of the agenda. Thank you. The third item on our agenda is to take evidence on the Conservation Natural Habitats Miscellaneous Amendments Scotland Regulations 2019 draft. I'm delighted to welcome back Rosanna Cunningham, the Cabinet Secretary for the Environment, Climate Change and Land Reform, and the Cabinet Secretary is now joined by Hugh Dignan, the Head of Wildlife Management and Biodiversity Unit for the Scottish Government. Good morning to you. Members will recall that we considered this instrument on the 24th of September and we reported on the 27th of September. The instrument was subsequently withdrawn and relayed, and the committee also wrote to the Minister for Rural Affairs and the Natural Environment, querying two matters in relation to this instrument, and we've had a response on them. The committee's letter and the Scottish Government's response to these queries available at Annex B of the relevant committee paper. And the DPLR committee considered the regulations this morning and had no comments to make. Now, do any of my colleagues have any comments? Mark?
It was just a brief comment, Convener. It was really on the back of the letter that was sent back to the committee from Mr Dignan, and it was about enforcement. So, I mean, these regulations are very welcome and extends the provisions around, you know, how we tackle invasive species. But I noticed in the letter it was saying that there's only been one enforcement agreement around giant hogweed in Scotland, and there's really no, there's been no sort of control measures put in place. No control orders, rather. And the suggestion is that a letter from SNH is often good enough to get action from landowners. That just plainly doesn't seem to be the case on the ground. So I'm wondering, how do we improve enforcement? Because it's fine creating a long list of invasive species that we don't want to see coming into Scotland, and obviously there's pressure with climate change as well as other issues as well. But if we're not enforcing it, except through an occasional letter from SNH to a landowner that gets ignored, what's the point?
I'll let you take that.
I guess I should say first of all that the question, which is obviously very relevant to a lot of the invasive alien species policy in Scotland, isn't actually dealt with directly by these regulations. So it's something which is already in place under the Wildlife and Countryside Act. And I think that the point that SNH are making is that most approaches to clearing non-native species, whether it's Himalayan balsam or giant hogweed, are best conducted on a large scale and typically on a river catchment scale. And that their policy is to use the enforcement mechanism where a landowner doesn't want to cooperate, and so it sort of renders useless the activities of the others. So what they're saying is that they usually find that people are willing to cooperate. These schemes do go ahead. I mean, there are plenty of schemes throughout the country to remove invasive species from river catchments. And on the occasion where someone indicates that they're not prepared to cooperate with their neighbours, a letter pointing out that the enforcement powers are there and available usually does have the effect of persuading them that it would be best to cooperate with their neighbours and work cooperatively to remove the species in question.
You say that's usually the case. There are numerous examples, I think, that various committee members were raising when we first looked at this, of where that action's not happening at all, that a letter from SNH doesn't really do it. And what you've indicated in your response back to committee is there are no control orders. So none of this is being enforced. It's all about a bit of coercion to try and get landowners to do the right thing. And that may happen in most cases, but it's not happening in all cases.
Well, as I say, I'm not aware from SNH that there is any situation where SNH have tried to coordinate a wider approach to controlling an invasive species and have been frustrated by an individual landowner, and that there's been an opportunity to take a control agreement and that hasn't been done. So, I mean, as far as I'm concerned, in cases where they do seek that sort of wider collaborative approach, they do usually get the cooperation from the landowners concerned.
Well, I could send them a list, but I'm sure other members might have a list as well.
Okay, we have a question from Stuart Stevenson.
I just wanted to follow up on that and ask if perhaps Hugh Dignan in particular is aware, for example, of the actions that Aberdeenshire Council, not led by my political colleagues, so I say good things about them in this regard. They're certainly taking action on a discovery of giant hogweed, and I just wonder if that is typical of what's happening across Scotland, that local councils are simply just getting on and doing it, and if it never really comes to the attention of the enforcement system at all, because the example of which I'm aware would be one where simply they're getting on with it.
Okay. Right. If that's all the questions, I'd like to move on to the fourth item on the agenda, to invite the Cabinet Secretary to move the motion S5M 19519 that the Environment, Climate Change and Land Reform Committee recommends that the Conservation, Natural Habitats, Miscellaneous Amendments, Scotland Regulations 2019 be approved. I invite the Cabinet Secretary to speak to and move the motion.
I was going to formally move, unless you particularly want me to speak to the motion.
You don't have to speak to it, just moving it is fine. Moved. Any comments from members? No. Right, I'll now put the question. The question is that motion S5M 19519 in the name of Rosanna Cunningham be approved. Are we agreed? Agreed. We're agreed. That concludes our session today. Thank you to the Cabinet Secretary and Hugh Dignan for their presence this morning. And that concludes the committee's business in public today. Its next meeting on the 5th of November. The committee will hear from the Committee on Climate Change on the Scottish Climate Change Adaptation Programme. The committee will also take evidence on Scottish Water's investment plan. We'll now move into private session, and I ask that the public gallery be cleared as the public part of this meeting is now closed.